Hi everyone, my name is Attorney Luceline Arat Kabading. In this video, we'll talk about a fundamental topic in remedial law, special proceedings under Rule 72 of the Rules of Court. Now, this topic often appears in the bar exam, and it's important to understand how it differs from ordinary civil actions, what types of cases fall under it, and how general procedural rules apply. So let's start. So what are special proceedings? Under Section 3C of Rule 1, a special proceeding is a remedy by which a party seeks to establish a status, a right, or a particular fact. That's the key phrase to remember: establish, not enforce. In an ordinary civil action, a party enforces a right, for example, filing for collection of money or recovery of property. But in a special proceeding, you are not enforcing. Rather, you're asking the court to recognize or declare something, like proving a will, establishing the death of a person, or approving an adoption. So, the focus is on the status, right, or fact. Now let's go over the list under Section 1, Rule 72. Though remember, it is not exclusive. The rules of court specifically mention proceedings like settlement of estate of deceased persons, escheat, guardianship and custody of children, trustees, adoption and rescission or revocation of adoption, judicial approval of voluntary recognition of minor natural children, hospitalization of insane persons, habeas corpus, change of name, constitution of family home, cancellation or correction of entries in the civil registry, declaration of absence and death, and voluntary dissolution of corporations. These are classical examples under Rule 72. But there are also other proceedings outside Rule 72 which are recognized by special laws and jurisprudence that fall under the same category. For example, liquidation of insolvent corporations, corporate rehabilitation, declaration of nullity of marriage, protection orders under the Anti-Violence Against Women and Children Act or RA 9262, and arbitration proceedings. So, even if a proceeding is not listed under Rule 72, as long as it seeks to establish a right, a status, or a fact, it is still considered a special proceeding. That is from De Leon and Wilwyko, 2020. So a common question students ask is, do the rules on civil procedure also apply in special proceedings? The answer is yes, but when practicable. So according to Rule 72, Section 2, in the absence of special provisions, the rules provided for ordinary actions shall be, as far as practicable, applicable in special proceeding. That means the ordinary procedural rules like filing requirements, pleadings, and motions may be applied suppletorily unless there is a specific special rule that says otherwise. And remember, the rules of court are liberally construed to promote a just, speedy, and inexpensive disposition of every case. So, in the case of Shecker versus Estate of Alice Shecker, GR number 157912, decided on December 13, 2007, the court ruled that the procedural requirements like certificate of non-forum shopping, written explanation for non-personal service, and the payment of filing fees, these all apply to special proceeding. Thereby, even if it's not an ordinary civil case, the same procedural discipline applies. The court emphasized that unless there is a special rule to the contrary, the rules in ordinary action apply suppletorily in special proceedings. Now, what about appeals? Well, according to De Leon and Wilwyko, the procedure for appeal in special proceedings follows the same rules as civil actions. So, Rules 41 to 43 of the Rules of Court apply, depending on the nature of the judgment and whether multiple appeals are allowed. Now, let's go through a quick bar question to apply what we have learned. So here are the facts. Ernie filed a petition for guardianship over his father, Ernesto. Now, after Ernie presented his evidence, Ernesto's lawyer filed a demurrer to evidence. Ernie's lawyer objected, claiming that a demurrer is not proper in a special proceeding. So the question is the objection proper? So the answer is no. The objection is not proper. The rules on ordinary actions apply suppletorily in special proceedings unless there is a special rule to the contrary. Since there is no special rule on demurrer to evidence in guardianship proceedings, then the general rule on demurrer under Rule 33 applies. Allowing a demurrer helps avoid wasting judicial time when the petitioner's evidence is already insufficient. So yes, a demurrer to evidence may be properly filed in a special proceeding if practicable. So the key takeaways here then are, for purpose, special proceedings establish a right, status, or fact, not to enforce one. In terms of scope, the list in Rule 72 is not exclusive. And we have to remember that in ordinary rules, this applies suppletorily unless a special provision provides otherwise. The concept of liberal construction, this is to promote just, speedy, and inexpensive justice. And demurrer is allowed when practicable, even in special proceedings. So in summary, when the law is silent, the rules of court speak. And in special proceedings, they speak suppletorily. All right, and that's it for today's discussion. If you found this lecture helpful, don't forget to like, share, and subscribe. Daghang salamat.